Hello and welcome to the A&MBacon podcast. Today I'm joined by Deputy Master Peter Haworth, and he's going to provide us with an insight regarding the recovery of costs at detailed assessment. Master Haworth is our brand ambassador at A&MBacon. He does have an impressive legal background and was admitted as a solicitor in 1975. And he became a district judge in 1992. He was also a member of the CPR Rule Committee between 1996 and 1999, and he's appointed Deputy Taxing Master of the SCCO in 2002, which became a full-time appointment in 2006. In today's podcast, I'm going to ask Peter to share with us some of his best ways to record time. So I welcome Peter. Good morning, Peter.
Good morning.
So I will embark with our first question. So we're seeing fee earners adopting an efficient approach to time recording, with some of those fee earners very much focusing on proportionality. So what we're seeing is examples of recording the content of a conversation with the client. So for example, in an email summary to them, to avoid them having to prepare a file note, they'll cover it off in an email summary to their client. If that approach was to be adopted, what would you like to see? Would a time recording note on the ledger referring to the email, for example, please refer to email dated, etc., for a record of the discussion? Would that assist with this suggested approach? And more importantly, is it sufficient in terms of supporting their claim for costs at detailed assessment?
All right, well, a very interesting question. Attendance notes, of course, fulfill a number of different purposes. Principally, they're there to record the advice that's given to a client, but as a secondary function, they provide objective evidence for the cost judge of what took place, who was there, how long it took, how important the discussion was, and I suppose most important of all, did it progress matters? As a consequence, cost judges and regional cost judges, district judges up and down the country have been using them to justify the time spent as long as lawyers have had to record time. There's never any hard and fast rules of what a time record should look like or how it should be presented at detailed assessment. And I suppose over the years I've seen them in every shape and form, written on the back of an envelope, written on a fag packet, just a general note, or a most loquacious 10-15 page attendance note, which sets out all the advice almost in tabular form given to a client, and almost effectively setting out the entire conversation with the client. To my mind, I'd be perfectly satisfied with an email summary of advice that was given to the client, backed up with a time recording note referring to that email. It sets out all the details that I've just referred to. It kills two birds with one stone, so to speak, and it seems a very proportionate and a sensible use of time in the electronic age. And of course, punctuated throughout our entire conversation this morning is going to be the use of the word proportionate. Proportionate is the bedrock now of recovery of costs in inter-parties litigation, and every lawyer who deals with litigation has to have that word at the back of his mind. Of course, file notes are undoubtedly best practice for lengthy conferences where the meat of the case is being discussed with the client, if only to protect the lawyer themselves from the client at the end of the day. Provided that the cost judge is presented with a neat bundle of emails, attendance notes, handwritten notes or papers, cross-reference to the chronological entries on the bill, the evidence is there to demonstrate the time claimed. That, to my mind, is a proportionate use of both the fee earner's time and the cost judge's time. What then happens is it simply becomes a value judgment by the cost judge to determine whether the time claimed is reasonable, and of course that word again, proportionate. So in short, yes, an email is fine, recording date, time, advice sought and given to the client.
Thank you, Peter. So proportionality really is key, and it has been for a long time. It's obviously in the forefront of any cost judge's mind whenever they're assessing anything, and likewise it should be in the forefront of the practitioners' minds as well. So that's really helpful and interesting to hear. So in terms of the way timed recording and in particular those more ambiguous entries, I think it would be helpful to give some guidance in terms of entries that are more vulnerable to reduction. So interference discussions is one of those. These are recoverable inter partes and are often required and indeed proved necessary to ensure efficiency of the running of a claim. However, they also can be duplication as well as supervision rather than being reasonable and necessary. And again, we're looking at the key point of, is it proportionate? Should it be delegated? Should it not? Should we be looking at having those interference discussions? Because delegation invariably requires those interfering discussions. But again, is that going to end up costing more in the long run? So proportionality is really, really key, as well as obviously reasonableness, as it always has been. So what sort of instances do prompt you to determine that these costs have actually furthered the claim, as you'd alluded to earlier, rather than simply being that supervision and duplication? I'm assuming that a detailed time recording entry is always key to be able to support that and help you to determine that, and a file note as well. So what would you really ideally like to see for you to get a full picture of what's happened in that time entry?
Again, another interesting point, fee earner discussions. I suppose the simplest way of looking at it, at this, is to put yourself in the position of the cost judge. Really, what does the cost judge want, or what has he got to do? It's very easy with hindsight, after a piece of litigation has been concluded, to say, well, this conversation wasn't necessary, X, Y, and Z. But that's not the situation that the cost judge must put himself into. There's a case a long time ago called Francis and Francis. And effectively, what the cost judge is meant to do is to put himself in the cost lawyers or the fee earners chair, as it were, at the time he made that decision. In other words, to look at the work that was done through that fee earner's eyes. And the only way you can do that, of course, at a much later stage, is effectively on the basis of what you see on the file. And of course, files these days are often electronic files, not the good old paper files that I was brought up with. And you often find particularly in points of dispute, oh, well, this was duplication, this was supervision. So how do you deal with that? Of course, a very proportionate use of time, especially these days, is to move work down the food chain, so to speak, to more junior fee earners where that's possible. It can't always be possible, and you may be able to justify senior fee earners for substantial elements of a job, and just use the more junior fee earners for the more mundane and day-to-day work. There's always going to be some where work is moved down the food chain. There's always going to be an element of supervision, and there's always going to be an element of explaining to that fee earner what the senior fee earner wants the junior fee earner to do. To my mind, that creates two elements. The first element of supervision is inter partes irrecoverable. The second element of the explanation of what you want the junior fee earner to do before that junior fee earner puts it into action is recoverable. So the simple answer, well, of course, there is no simple answer, but a simple answer is transparency, and to make any attendance note of that inter partes discussion show that it had two elements. You won't get, you may you be able to claim a part of that interference discussion, but obviously the supervision element, which there's bound to be over time, that will not be able to be recovered. But be open and transparent in the attendance note, because I'm quite confident that the cost judges and district judges up and down the country will simply be able to see through, as it were, any subterfuge by a fee earner to try and claim something which perhaps is irrecoverable between the parties. Team meetings, for example, can move a case forward. Often you have a meeting of 2, 3, sometimes 4 fee earners in heavy commercial litigation, often more. Minute the points discussed and the relevance to each fee earner, that again I think is a useful exercise. Again, it's about the cost judge making a value judgment in relation to your time. So certainly examples of what is not recoverable, and what I've seen over the years is where you have a meeting with the client. There may be 1 or 2 senior fee earners there. There's a junior fee earner there who's taking a note. The scribe, in other words. To my mind, on a standard-based assessment, the cost of the junior to take that note will always be irrecoverable. It's highly unlikely that you would persuade me that, oh, well, the senior fee earner needed to have the flow of the conversation with the client, didn't want to be taking a note. But of course, that note these days can always be recorded either on your computer or on a machine in some form or another. So again, always have in the back of your mind, is this meeting progressing the case? Is it moving it forward? Or is it administrative? Or is it both? And don't try and claim effectively time inter partes for matters of an administrative nature.
Thank you, Peter. That's really, really helpful. Particularly in terms of having that insight, because we hear so many times about how it was necessary for those particular members to be in the team, in that team call. I also thought what was really helpful from what you've said was that explanation aspect to give to the more junior fee earner is recoverable. And sometimes it may be that it's not been quite fully understood during that conversation, and therefore the junior fee earner ends up having to spend more time undertaking a task than perhaps would have been necessary. So I think one of the big takeaway points from that is actually to have that clear instructions to that junior fee earner to make sure that actually they fully understood what's happening, and perhaps a checkup of that before the actual task has been completed. Would you suggest, would you think that that was a good idea? Because sometimes they can go off and complete it and in a hope to impress their senior, and they've gone down the wrong route.
Well, yes. I mean, an explanation of what you want may take 2 sentences. Of course, mine did. It might simply say, take the file away and go and pick out all A, B, C, and D documents. End of explanation. The explanation might take 20 minutes, depending on what they want to do. But provided that is expressed again clearly in some form of note that or minute that the cost judge can ultimately see, I can see no point why, given proportionality, again, that is not recoverable. And of course, the junior fee earner goes away and presumably would spend more time than the senior fee earner doing it. But the consequent saving in time is based, of course, on the differential in hourly rates.
Yeah, that's good to hear, because we often hear, our opponents raising particular arguments that may not support what we've been fed back, and obviously there's always a negotiation when we're looking at costs. So it is helpful to hear what the cost judges are actually thinking in those more ambiguous entries. So another ambiguous one is research time. Are there instances where you consider, given that the solicitors are experts in their field, that research time is recoverable? Perhaps it might be a particularly unique point that, we aren't in artificial intelligence that can remember absolutely everything. And again, does it depend? Can an element of research time be allowed, or is it a case of no, research time's not recoverable. What's your thoughts when you see that? Again, is that a balanced view?
Research, again, is one of those very grey areas. I think I must have seen hundreds, if not thousands, of sets of points of dispute where the paying party claims that the work was research and should all be disallowed. I think it's axiomatic that the stock in trade of a lawyer is a knowledge of the law. So you're meant to know the basics. If you're being put forward as a specialist in whatever field it might be, clin neg, personal injury, then in those circumstances, you're meant to know more than the basics. You're meant to know a good deal of additional law. You're meant to know your field in those circumstances, and particularly if you're a litigator, you're meant to know the ins and outs of CPR. For example, again, I've seen bills where there are swathes of time claimed for researching perhaps fairly abstract areas of CPR, but the reality is that you're unlikely to recover costs for researching the rules of court. It's something that you're meant to know. Whether you know them or not is another matter. But what you're not meant to know is every particular case in your particular field. And it seems to me that where, for example, there is a novel point of law or a difficult issue that hasn't come before the courts for some time, then in those circumstances, you may have to go back to the books. You may go to counsel, which of course is a different matter. But it seems to me that certainly I've allowed in the past substantial costs for lawyers researching case law to persuade the court that this novel point of law should be taken on board. Another area where points of dispute or bills often claim costs for research is researching, for example, looking for specialists and a whole number of experts to go to in a particular case. And to my mind, if you're being put forward as a specialist, it's unlikely that you're going to be able to recover anything at all for going to research lists of specialists for a particular claim. To my mind, again, you're meant to that's your stock in trade. You're meant to have a list of the experts you would use time and time again. So, but on the other hand, it seems to me that researching, for example, the background of a witness might be quite important, depending on the credibility, if there's credibility of that witness. And in those circumstances, research into the background of a witness may be recoverable in those circumstances. Or, for example, a limited company where a claim involves a company that might be in difficulties or about to be in difficulties, then in those circumstances, researching the background of that company or its directors, again, might be a way forward. The list is endless, I think, but the reality is, I think, if it's a relatively basic area of the law, then research is not going to be recoverable. It needs to be something of a very specialised nature to be able to recover those costs on an inter-parties basis. And I think that's as much as I can say on that point.
Again, that's really helpful. Thank you. Particularly in that grey area, often we're advising our clients exactly as you refer to it. This is a very much a grey area. So to have that insight is really, really helpful. So thank you for that, Peter. Moving on to a further question, it's just more of a general question, really, in respect of time recording and file management. Is there anything you yourself really likes to see, you know, when you get a file that you, or a bill or points of dispute, anything within the cost arena that you think, yes, that's just spot on, that's what I like to see?
Yeah, again, a very useful question. I must have seen thousands of files over the years when I've been doing this job. And often you can tell all about the fee earners or the firm involved before you even open the file, or certainly on opening the file. At one extreme, I've been presented with a box, a banker's box of papers, where simply it looks as though they'd simply been thrown into the box. And I was meant effectively to extract the relevant bits of information, like a rabbit out of a hat, to be persuaded that these costs were reasonable. On the other hand, you have meticulous bundles of papers where solicitors and lawyers have cross-referenced each element or each attendance note that's in dispute, in the points of dispute, so that I can immediately go to that attendance note and flag them up. And these days that can be done electronically. To my mind, that saves a huge amount of time, of court time. It might not always be proportionate in a smaller case, but certainly in the larger cases, that's, I think, what cost judges will now expect to see, that effectively where there is a dispute, that the documents to support the claim can literally be flagged up and pinpointed by the press of a button. In the old days, of course, perhaps not just the old days, but there is less and less use now of paper files. If you have a paper file, the way in which the cost judge wants to see it is set out for all to see in the practice direction. All you've got to do is read the practice direction PD 47, paragraph 1312, and that tells you exactly how the cost judge wants to see your papers in appropriate chronological order. The order really has got to be on the basis of how it looks in the bill, because if he then can tick it off, then it's going to save him time, it's going to save his temper, and it's going to assist you in recovering more costs. I think with the electronic files and bundles, you have got to be careful as to what you put in those bundles. What I tend to see are just reams and reams of these chains of emails that sometimes assist, but sometimes don't assist. Where possible, keep those chains of emails short, and remember that the cost judge doesn't want to see your shopping list, or he doesn't want to see what you've had for dinner the night before, or any chat between you and your contemporaries, either in the office or elsewhere. So I think the moral of the story is check the file before you send it. You're paid to vouch the bill. If you're the fee earner with supervision of the file, it pays to make sure what is being sent to the SCCO or to the district judge is what you want him to see, which is going to advance your case and recover you some costs. One good example, for example, of what I mean is that I have in the past seen a letter on the top of the file, which obviously had been sent by the fee earner to the cost lawyer when the cost lawyer was drafting the bill, and which the cost lawyer hadn't taken away, which said, whatever you do, make sure that the cost judge doesn't see this letter. Well, of course, I did see the letter. So I did know what was in the letter, and of course that was the first thing that I gave back to the fee earner and cost lawyer when we had the detailed assessment. So, and of course the rest is history, as they say. So the watchwords, it seems to me, in relation to what is important in providing the court with the documentation is common sense, transparency, watchwords of necessity, proportionality, and economic use of time. And bearing those factors in mind, it seems to me that you can maximise recovery of costs in the case that you're having your costs assessed.
Again, Peter, really helpful to have that insight into the working practice of what you require from ourselves and our profession. We're nearly finished. We've got the final question, and we're finishing on the hourly rates, the new SCCO guideline hourly rates. What's your view in the latest approval of the rates, and in particular this new heavy commercial band for Central London? Do you envisage any forum shopping, and whether there's any instances now where those London firms will be able to get an increase on those rates?
Well, the first comment I have about the new guideline rates is it's about time too.
Isn't it?
The increases in hourly rates may look dramatic, but they haven't changed since 2010. And hopefully implementation of these new rates will reduce points of dispute and replies by at least 2 pages, as well as the endless hours of argument, which I think every single detailed assessment I've conducted over the past, it must be 5 or 6 years, has involved an argument about hourly rates and about the guideline rates, when it sometimes has been totally unnecessary. I think one change, and what I would say is, I'm sure that most lawyers think they know the guidance in relation to hourly rates backwards, but it will be a great benefit, I think, to all practitioners who litigate to actually go away and read the new guide that was published by the SCCO last Friday. And one of the changes in significance, I think, of significance in the guide is at paragraph 28, where the guidance makes clear that guideline hourly rates may also be a helpful starting point on detailed assessment. So the clue's in the title, isn't it? The title of the publication is the Guide to the Summary Assessment of Costs. And as I've said, I think, to virtually every advocate who's come before me over the past 10 years, that guideline hourly rates, particularly in the sort of cases that I deal with, a detailed assessment, are a starting point, but very rarely the finishing point in a detailed assessment. I think now, however, courts will probably take a more strict view to apply guideline hourly rates to detailed assessment in perhaps the smaller cases that come before the county courts, not perhaps the larger litigation that comes before the SCCO in London. Forum shopping, I don't think that's going to happen. Yes, there is a heavy commercial rate for Central London, but it's not going to work with cost judges and district judges, who I think will be vigilant only to allow local rates. And again, paragraph 31 of the new guidance makes that pretty clear, that where work is done in a different location from that of the solicitor's office, the payment of that work is determined by reference to the office which he or she is predominantly attached, and that will be I think, policed fairly heavily by cost judges and district judges up and down the country. Again, as a final pointer, and I'll finish where I started with the use of the word proportionality, is that useful guidance again is given in the new guidance on how proportionality should be judged by reference to the West case, and you'll find that in paragraph 15 of the guidance. Although a lot of that guide is a rehash of previous editions, I think it'll pay practitioners dividends to reread what they think they already know. And with that in mind, I'll leave hourly rates there. The other thing about hourly rates, of course, is they do say that they will be reviewed again in 2 years' time, but I'm happily have a wager with you, Sue, of 50p that we'll have this same conversation again in August 2023.
Maybe we could up that to £1 then. Thank you. I mean, again, some really, really helpful key points. Again, a lot of those areas that our industry argue about. So it's really, really helpful to have some clarification. And as you say, the summary assessment guide, again, helpful to hear that it now does relate to detailed assessment, and also your points on the forum shopping. That's really helpful too. We really do appreciate you giving up your time, your precious time today, for answering these questions. And we do really look forward to you sharing some of your extensive experience in a next podcast that we may record. Thank you.
Thank you.